This part of the class is on norms for online dispute resolution. We have already studied the e-commerce directive, and if you talk about the e-commerce directive, you immediately, of course, think about Article 17 and 18. But even in the recitals, you can find relevant and interesting observations by the drafters of the directives. In the recital 51, they say that the member states should amend any legislation which is liable to hamper the use of schemes for the out-of-court settlement of disputes through electronic channels. I'm not sure whether there existed many laws that hampered the use of electronic out-of-court schemes, but as far as they existed, I'm also not sure whether they have disappeared. But generally, I think because the formality of alternative out-of-scheme processes is not that high, it's of course no litigation, there's less formality, so I do not believe that there are any parts in existing codes that hamper the use of out-of-court settlement of dispute through electronic means. Through electronic means might be a problem in some countries, but in most countries it wouldn't be that much problem. The in writing, which can be an issue of a verdict or contract, is already solved by Article 10 of the e-commerce directive, as we know. In recital 52, we can read that there should be an effective access to means of settling disputes, and that must include appropriate court actions being available. And you can really doubt whether courts can really offer good solutions for e-commerce disputes. I think that alternative forms, mediation, negotiation and arbitration, are far more suited to deal with e-commerce conflicts than traditional courts are. If we then go to the Articles 17 and 18, you can read it for yourself, but I will quote from Article 18, a small part. In subsection 1, it states that court actions available under national law concerning information society service activities should allow for the rapid adoption of measures, including interim measures designed to terminate any alleged infringement and to prevent any further impairment of interests involved. Well, that's a bit funny, because how can you expect litigation to be rapid and including measures that can terminate infringements? Of course, you have summon proceedings, but generally it will be quite problematic to have the court resolve these issues in a fast and adequate way. So again, you could better use alternative mechanisms, because speed is yet another important element of alternative dispute resolution that adds to what litigation can offer to consumers taking off services online. So in the e-commerce directive, you basically find the incentives for member states to adopt, where necessary, legislation, and to initiate also the online processes, or at least to have court actions that allow a good solution of problems occurring online. If we in general look at the difference between alternative dispute resolution and litigation, one point on which both differ is the procedural safeguards. Litigation is a more expensive process, is a process that takes more time, but all those benefits of alternative dispute resolution, of online dispute resolution, the arbitration, e-negotiation and e-mediation come with a price, namely that, and I quote Suzanne Schiavetti, disputants may be willing to accept the weakening of certain procedural safeguards, so long as this is compensated for by other benefits accruing from the use of ODR, such as cheap and fast resolution processes. Well, that's a good point to start with, and the regulation that Schiavetti proposes in her 2008 doctoral dissertation, Electronic Alternative Dispute Resolution, Increasing Access to Justice via Procedural Protection, is also builds upon the Article 6 of the European Convention on Human Rights, in which, as you probably all be aware of, it is stated that in the determination of his civil rights and obligations, everyone is entitled to a fair and public hearing within reasonable time by an independent and impartial tribunal established by law. These are the basic fundaments of litigation, the fundaments that the dispute resolution processes organized by the state, by the national authorities, should comply with. Alternative dispute resolution, so the online dispute resolution, for instance, e-arbitration, e-mediation and e-negotiation, could be a bit less fair, hope not of course, could be faster, so even more within a reasonable time. The tribunal might be a bit less independent or impartial, or there might, and that's really an important difference, there might not be a public hearing. Everything in litigation, except for some penal cases or cases in which minors are involved, every litigation process is public, and alternative dispute resolution is often in a confidential setting. So mediation, there's no audience allowed when the case is mediated, and in arbitration there normally also isn't an audience allowed. And for particular companies that might be a big benefit, because then the outcome of the process not necessarily will become public. But that's something that the norms on online dispute resolution, the norms on alternative dispute resolution try to repair, namely by forcing the providers of those services to publish the results of procedures in anonymized form, so that you can be informed about what was ruled by an arbiter or what was reached as a solution by a mediator, at least in a meta level, which can also be possible, that they indicate we had 100 cases on this topic and they were resolved in favor of the plaintiff in 80% of the cases. That kind of information is a sort of minimum that is required under all kind of regulations for ADR and ODR, which are, most of them, voluntary. So the recommendation from '98 on arbitration by the European Union, the recommendation from 2001 on mediation by the European Union are, as the word also says, recommendations. So it's not an obligation for member states to comply with those norms. And that's of course a problem with alternative dispute resolution. How can you enforce norms in processes that are confidential? How can you control it? Public hearing, the element of the European Convention on Human Rights, public hearing is of course also meant to control the judiciary, that they can do strange things during processes. There's the opportunity to sit by a court case and see what's happening, and this opportunity isn't there in case of mediation. So that's an important point to keep in mind, and it also is something that makes it difficult to enforce norms to those processes, to make norms that are applicable to those providers of online dispute resolution services. If we look at the vision that's also made in the chapter made available via Blackboard from the book that I wrote with Jan Selesnikov, you have, to begin with, the general norms, electronic norms that are applicable to trade online or at a distance. And online dispute resolution complies with the definitions of distance selling in the services way, of course, distance deliverance of services, and it's an information society service offering an online dispute resolution service. So all the norms we discussed during those classes also apply to online dispute resolution providers. Then there are norms that are drafted for alternative dispute resolution in general, the two recommendations I just mentioned, and also specific norms for online dispute resolution, and the most prominent example there is the recommendation by the American Bar Association. If we take a look at the recommendations on arbitration and mediation, we can see that the most relevant concepts here are, and we recognize it from the fair trial principle of the European Convention, impartiality, independence. It's of course also very important in online dispute resolution. Who's paying for the service? Is it the company that has a website that pays for the service? That could be an indication that the provider of the dispute resolution service isn't independent. Transparency is important, that information is provided about how the process is conducted, what you have to pay, what the outcome will be, who, if they are involved, who are the third parties, possible third parties, the arbiters, the mediators. Normally a list provided with information about those people so that you can choose someone. And what could help in selecting the right arbiter or mediator will also be some history about the prior cases that he's done in the past. And transparency is of course a bit opposite in a way to confidentiality, which is an important element. So that's the public hearing part of the convention that isn't present in online dispute resolution, the alternative forms of it. And that's something that's seen as very important. If people do not trust, here we have this trust element again, do not trust the online dispute resolution services, then they won't use it. And being sure that what's exchanged during those online processes is kept confidential adds to people trusting those services.